Hey there, everyone. My name is Charles Deland, and I'm Associate Director of Research for the CD Howe Institute. I lead natural resources and energy policy research here, and my colleagues and I are thrilled and excited that you're here to this event. Thanks, first of all, for your support of the Institute. Our members are the foundation of our mission, fostering smart economic policies and raising the living standards of Canadians. So today our topic is the Supreme Court federal overreach in the Green Agenda. A little bit of background: on October 13th, the Supreme Court released its decision in a reference case about the Impact Assessment Act, which governs federal environmental assessments in Canada. The Alberta government viewed that as encroaching on areas of provincial authority and asked the Alberta Court of Appeal whether it was beyond the federal government's authority. And in a majority opinion, they concluded, the Supreme Court, that the portions of the scheme dealing with federal projects were clearly unconstitutional, but that the balance of the scheme was constitutional, but the balance of the scheme was unconstitutional, and that, quote, Parliament has plainly overstepped its constitutional competence. So that decision raises big questions about the federal government's ability to regulate certain environment matters, things like potentially clean electricity regs, cap on oil and gas emissions in Canada, or even a zero emission vehicle mandate. Why does this matter? It matters because Canadian standards of living rely on building and operating large, complex physical projects. Things like extracting and selling natural resources like oil, metals, minerals, moving those throughout Canada and to buyers around the world, and to generate and transmit electricity needed by Canadians and to power the company operations. On the other hand, Canadians also expect the regulatory system to ensure that negative impacts, like environmental ones, be assessed and make the trade-off on various courses of actions understood. With that in mind, how regulation is done and confusion about who is doing that unnecessarily makes large projects slower or more expensive or less of it than it needs to be, that all lets Canadians down. So the Institute has covered this for a long time. For example, in 2019, we released a major research paper titled A Crisis of Our Own Making, Prospects for Major Natural Resource Projects in Canada, which found that then Bill C-69, the Impact Assessment Act, threatened to depress investment and delay projects by unnecessarily exposing them to political risk. With that in mind, it's my real pleasure to welcome our two speakers today. The combined breadth and depth of their skills and experience on regulatory topics make them almost uniquely qualified to speak today. In no particular order, and shortchanging them on their descriptions for the sake of time, the full bios are on the website. First, I welcome Brad Gilmour. Brad is a partner and the head of the Bennett Jones Facilities, Projects and Approvals Practice, and co-head of Environmental Department. His practice focused primarily on environmental, energy, regulatory, and Aboriginal law. And Brad was also one of the lawyers appearing before the Supreme Court in this case. And I have the pleasure of currently writing a paper with Brad on improving permitting processes. Second, I also welcome Grant Sprague. Grant served as Deputy Minister for Energy in Alberta from July 2013 to May 2016, and again from April 2019 to 2023, dealing with numerous complex and interjurisdictional issues. His extensive governance and legal background from the private sector as well, and is also a senior fellow at the CD Howe Institute, where he's written a few short pieces for us and is writing something else for us at the moment. So without any further ado, I will turn it over to Brad and Grant. First, each will spend about 8 to 12 minutes with some prepared remarks, followed by questions and answers. As they go, please enter any questions into the Q&A section on the right-hand side panel. If you don't see it, click on the bottom right-hand. There's a few dots there, and it should show up. With that, I will turn it over to, I think Brad is speaking first.
Yeah. Great. Thanks, Charles.
Thanks.
Good morning, good afternoon, everybody. I thought I'd start off by talking about what do we mean by federal overreach in the context of what we're discussing today, which is really environmental and natural resource regulation and those sorts of things. I think what we're really talking about is whether or not recent decisions of the courts are telling us that the federal government or Parliament has implemented legislation to regulate matters related to the environment and resource development that go beyond its jurisdiction. And I think that the answer to that question quite clearly is yes. And to make that case, two recent decisions of the courts are important to consider. One being the reference case that Charles referenced, the reference case in respect of the Impact Assessment Act, or more popularly referred to as Bill C-69. but also a case that came out from the federal court that followed on the heels of that decision, which looked at whether or not the federal government's proposal to regulate a broad class of plastic manufactured items, so plastic straws, plastic bags, and those sorts of things, under the toxic substance provisions of the Canadian Environmental Protection, was a valid exercise of jurisdiction by the federal government. And the answer to that was no. And so I think both of these cases are quite important in answering that question of whether or not the federal government has exhibited examples of overreach in terms of what their jurisdiction is in these areas. And they necessarily feed into what are some of the important issues that are future issues, and that would include the scope of federal impact assessment generally, and what the revisions to the Impact Assessment Act might look like, the regulation of energy and natural resource activities generally, and I think greenhouse gases as well. So I suspect today we'll discuss on some of those things, and perhaps more particularly proposed regulations to place an emissions cap on the oil and gas industry, the clean electricity regulation, and recent proposed methane reduction regulation. So I think these cases are important in assessing the concept of overreach in respect of that pending legislation. So let's start with the impact assessment decision. And I will want to make clear as well that my partners, Bruce Mellett, Sean Essier with Bennett Jones, joined me on that case, as well as great help from the Alberta Department of Justice. So there were a lot of lawyers that contributed to this case, including the other attorney generals and various other groups that appeared before the Supreme Court on this case. It was a reference case. So what is a reference case? A reference case means that the province of Alberta sent a question to the Alberta Court of Appeal, and the question sounds simple. Is the Impact Assessment Act and its related regulations, are they unconstitutional in whole and part? Simple question, complex answer. And our Alberta Court of Appeal said, yes, both were unconstitutional in their entirety in a 4-1 majority decision. That went to the Supreme Court of Canada. As Charles indicated, Supreme Court of Canada said yes, with the exception of what I would characterize as 10 non-controversial sections of the Act that everybody agreed were constitutional. It was a 5-2 majority decision. It was written by the Chief Justice of the Supreme Court of Canada, which in itself is important, I think, in assessing the implications of the decision. Recognizing I have 8 to 12 minutes, I'm sort of hesitant to go into this area, but I think to understand the concept of overreach, we need to talk a little bit about the Constitution Act of 1867 and the division of powers under that. Generally speaking, most of the powers are divided under our Constitution in sections 91, 92, and 92A of the Constitution Act. Federal powers largely under section 91. And in relation to what we're talking about today, the federal government has jurisdiction over things like navigation, which gives us the Canadian Navigable Waters Protection legislation, fish, so the Fisheries Act, the criminal law power, which supports the toxic substance provisions of the Canadian Environmental Protection Act, interprovincial and international works and undertakings, so things like international and interprovincial pipelines or electrical transmission or railways, clearly within federal jurisdiction, and then a residual power called the peace, order, and good government power, which I'm not going to get into in any great detail, but there are certain examples where the courts might validate a federal legislative proposal under that section, but it's rarely used. And we may get into that part of the discussion. On the provincial side, it's the provincial government that has jurisdiction over local works and undertakings. So feds, interprovincial, international works and undertakings, province, local works and undertakings. That's pretty much most of what else we do. So if you look at whether it's conventional oil and gas or oil sands development or within province pipelines, highways, power projects, those are all local works and undertakings. And of course, they're regulated through their life cycle by recognized and expert provincial regulatory authorities like the Alberta Energy Regulator, the Alberta Utilities Commission, and the like in Alberta, and similarly in other provinces. Property and civil rights, matters of a local and private nature, and then into Section 92A of the Constitution, provinces are granted the exclusive jurisdiction to make laws in relation to the exploration for, development, conservation, and management of non-renewable resources, so mines and hydrocarbons and the like, forestry resources, and sites and facilities for the generation and production of electrical energy. So these are exclusive areas granted to the provinces. Where's environment? Well, environment wasn't listed as a specific power. So over time, the courts and the various levels have had to figure out, where that dividing line is in respect of the environment. But fundamentally, if a level of government is going to regulate in the area of the environment, it needs to tie that to an existing power that it has under Section 91, 92, or 92A. So that's the refresher on the Constitution Act. The getting back into the decision of the Supreme Court of Canada in the impact assessment case. So that, again, was a reference in relation to the federal government's latest version of impact assessment in respect of new project development. This all really started back in the mid 90s with a decision of the Supreme Court of Canada that we called the Old Man River case. That looked at really what was the first version of the federal environmental impact legislation called the ERPGO, or the Environmental Assessment Review Process Guideline Order. And in that case, the court looked at that legislation, and the constitutional validity of that was being considered. And the court said it was constitutional for the federal government to have legislation of this type. But importantly, the court said that's because it's really just procedural legislation. It's designed to gather information about the environment that importantly will be tied to and will inform other valid federal decision-making under other valid federal legislation. So like the issuance of a permit under the Fisheries Act or under the Navigable Waters Protection Act was merely designed to inform that decision from an environmental perspective. It was then turned into the Canadian Environmental Assessment Act 1992. That was similar to the ERPGO. The door into the legislation was very clear. Again, it was very much tied to valid federal decision making. The CN 1992 came out. I'm going to skip that largely, but just to make the point that I think that's where the problem started. The constitutional validity of that statute was never challenged. Then came the IAA, which was really similar to the CN 1992, or sorry, similar to the CN 2012, but greatly expanded in a number of respects. Fundamentally, what's important to understand why this is different and why it was ultimately found to be unconstitutional is that door into the legislation that tied the implementation of that legislation to clear federal decisions was gone. And what mattered now was not whether or not there was another federal decision to be made in respect of your project, but merely whether or not your project was in a list on a regulation and there was the possibility of an effect within federal jurisdiction. And so if the answer to both of those was yes, then you're into the legislation. So it wasn't necessarily tied to the fact that I needed a permit under the Fisheries Act. And in fact, what ended up happening is a number of projects that were largely never reviewed by the federal government or didn't involve any federal permits ended up getting captured under this legislation. And so therefore the IAA became not only an information gathering process, but it itself became the decision-making legislation. This was the legislation that at the federal level could decide whether or not what have historically been provincially regulated projects, or the provincial regulator determines the public interest, granting power purportedly to the federal government to itself decide whether or not the project is in the public interest based on federal priorities. And the problem with the legislation, there were several problems, but one of the fundamental problems was that concept of effects within federal jurisdiction, which was a defined term, according to the Supreme Court of Canada, were not in fact effects within federal jurisdiction. So by calling them effects in federal jurisdiction wasn't enough. They needed to actually be related back to specific powers, like the fisheries power, in a way that you could reconcile with the existing interpretation of the scope of those powers. And the court said, no, this is way too broad. It goes way beyond those areas of federal jurisdiction. These aren't areas of federal jurisdiction, hence overreach. And that's where we end up with overreach under this legislation, I think in terms of the takeaways from that decision, there were really three. So in terms of, I guess, probably most closely to the concept of environmental assessment of projects that are being proposed, what the court said that if you're the level of government that has jurisdiction over the activity, so I think it's easy to think about it, well, the feds have jurisdiction over interprovincial, international, local works and, international or provincial works and undertakings, things like interprovincial pipelines, for example, then you have broad jurisdiction to regulate that activity. Similarly, the province, who has jurisdiction over local works and undertakings, has broad jurisdiction to regulate that activity. On the other hand, if the other level of government is going to regulate, and usually in those circumstances, it's now regulating a resource or an effect. Let's take fish, for example, at the fisheries at the federal level. Then that regulation must be tightly tied to the fisheries power. It needs to be about the regulation and protection of the fishery. It can't be about greenhouse gases. It can't be about how we reclaim sites and those sorts of things. It's got to be about fish. So that was one of the fundamental takeaways from this decision. I think not directly related to assessment, but beyond that, court was also very clear that the federal government does not have broad jurisdiction over greenhouse gases. And that's certainly important, not only in the context of the impact assessment, but also in the context of some of the future pending federal legislation. And then I think what was also important is to recognize that there was nothing incorrect or different in the law determined by the court from the Old Man River case back in the 1980s. Like the law, the interpretation of the Constitution didn't really change. Old Man River is still valid. What changed was the degree to which the federal government was relying upon that decision to legislate. And it led to legislative creep and ultimately this concept of overreach. So that's what I wanted to say about the IAA. I think also fundamentally important as we kind of look forward in the near term here is what I'll call the plastics case. So this was where Parliament at the federal level purported to list and regulate a broad class of plastic manufactured items as toxic substances under the Canadian Environmental Protection Act. Now, what's important to understand that, again, we go back to, well, where did the basis to regulate pollutants or toxic substance come from? How is that tied to federal jurisdiction? And for that, again, we need to go back to an older case in the mid-1990s, a decision of the Supreme Court of Canada, which was a narrow 5-4 decision that upheld the toxic substance provisions under the criminal law power of the CEPA, but within the context of a handful of substances the court said are toxic in the ordinary sense. So when they were considering the ability of Parliament to regulate pollutants under the criminal law power, it was considering a very narrow group of chemicals that the court said are obviously toxic. So PCBs, mercury, lead, asbestos, vinyl chloride, things that I think most people would say are obviously toxic. But over time, since that decision, more substances have been added to the list, some of which are surely toxic in the ordinary sense, but also substances like carbon dioxide and plastic manufactured items. So the question then becomes, how broadly can the criminal law power be used to regulate substances? And are things like carbon dioxide and plastic manufactured items toxic in the ordinary sense as contemplated by the court 30 years ago in the Hydro-Quebec decision? That will be part of the consideration, I think, going forward. And it's important to note that even in that decision, the Supreme Court majority recognized that a prohibition under the toxic substance provisions could, quote, could be so broad and all-encompassing as to be found to be in pith and substance really aimed at regulating an area following within provincial domain and not exclusively at the protection of the environment, end quote. So even in that case where they upheld the toxic substance provisions, there was this concern that they could be overly used, if not reasonably constrained. So the plastics case really looked at that issue in a fair bit of detail, and this was a federal court decision, so it's not at the level of the Supreme Court, but it determined that this broad capture of plastic manufactured items was not supported by the criminal law power or the toxic substance provisions, and therefore was unconstitutional. That decision is now under appeal. So again, an example, I think, of telling us of this concept of overreach. I'll finish off at this point and then hand it over to Grant. But really, I think then now the attention really starts to turn to what do these cases mean for things like an emissions cap on oil and gas, the clean energy regulation, and various other potential proposals at the federal level. Grant?
Thanks very much, Brad, and good morning, everyone. I think Brad's given us an excellent summary of what the courts have been saying lately, and I thought I'd maybe start just with a bit of a reflection, how we got here, independent of that legislative development. And my engagement started back in May of 2019, and you'll recall that we just had a provincial election in Alberta. The controversy about Bill C-69 was ongoing. It was very live. Various hearings were being held. And I can recall in my new job as Deputy Minister of Energy that my brand new minister, Sonia Savage, on her first day was told, "You're going to Ottawa. You're going to Ottawa and you're going to talk about the challenges of Bill C-69. And so the issue was very live back at the beginning of that administration, and indeed was reflected in the extensive policy platform that had been put forward by then to be Premier Kenney. What the concern was, and again, while it's often referred to as the No Pipelines Bill, was much broader. And it was, as Brad described, this idea that the environment was being used as a Trojan horse, as a mechanism through which the federal government was going to be able to come in and regulate everything or anything that it chose. And this was, I think, as Brad rightly described, a significant change from what initially had been environmental assessment legislation, going back to the guidelines order back in the Old Man Dam case. So we've moved a far way from just looking and considering the implications so that the federal crown could impose appropriately conditions or concerns about its areas of jurisdiction, and turned it into this much more grand process by which the federal government could determine whether or not any project that had any hint of a federal piece, whether they could determine that it was in fact not in the public interest. And we in turn saw the federal government do that precisely in Alberta. I can recall there was a coal facility up in Edson in that area that was proceeding, and the federal government a priori made the determination, no, you can't proceed with, I think it was an expansion, because it could have bad environmental effects. And that change, that switch from looking at environment as an area where clearly the federal government has some areas of valid concern, and then turning it into almost a plenary head of power is a significant concern, and resulted obviously in the provincial crown asking for the reference case to be made to the provincial court, and of course Brad and his team carried that forward. It is important to know, and Brad also mentioned this, but I think it's worthy of note, the number of provinces that also participated in this reference in support of the question that Alberta was raising. So while, yes, often we heard about the no pipelines element, it was much broader and attracted a far more significant concern from many of the provinces. In fact, I think most of them. I think there were two that didn't come in. And I think that's the reflection of why this is a broad topic of concern, and should be a broad topic of concern to Canadians as we move forward. For me, I want to talk about two takeaways that I had from the IAA case, and then reinforced really by the plastics case. So the first one we've talked about, and that's the substance. The substance, how broad can you engage on the topic of environment if you're the federal government in particular? And again, I think the nuance that we've added, the court has added since the Old Man Dam case, is that the environment has elements that will affect both the federal and the provincial crowns, but it is not a plenary shared area of jurisdiction. I've listened to the heresy that it's an area of shared jurisdiction, therefore, either level of government could do whatever they chose. In my view, I think the Supreme Court has now put paid to that quite clearly. No, one needs to start with a valid, rooted area of jurisdiction, and there may be environmental elements to that jurisdiction, but it doesn't work the other way around. And for me, that is a substantial change in how we are looking and at any of our regulations as we go forward. I think that narrow construction, more narrow construction that had been sought, places a number of federal processes and regulatory actions into question. And I am concerned that we are going to continue to see testing of those outcomes unless there is some greater degree of clarity and cooperation. Brad mentioned a couple. I mean, the clean electricity regulations, that's a very interesting one. Again, rooted, as I understand, in SEPA, which goes back to that criminal law power. The more it looks like we're regulating electricity production, I think the more difficult it will be to sustain that legislation. The oil and gas cap that's been promised will be another one that I think will be challenging. Likewise, the zero emissions vehicle policy and process that's going to come forward. At a certain point, it starts, again, one can label everything presumably the criminal law power and say, well, if you breach anything, that will be a problem. I think our Supreme Court, going back to the Hydro-Quebec case, was pretty clear. There are key elements that you need to look at, and the more it looks like a regulatory system permitting the use of certain things, and gets away from absolute prohibitions, the harder it will be to sustain. So I think that's going to be very interesting to see. I think we've seen provincial governments across the country sit up and pay attention to this overreach and are considering challenges or other engagement, let's just call it that, with our federal government in certain of those areas. The one, and this is maybe a hobby horse of my own, but the one area, for example, that always struck me as being very questionable in terms of federal jurisdiction is the Species at Risk Act, which crops up and has cropped up in a number of ways across the country. And while we might all agree, laudable outcomes, everybody's interested in preserving species. I've always questioned in my mind, where's the federal hook? Where do we start with that? If we're talking about small plants that are found on provincial crown lands, I was curious where the federal government jumped in on that. So we'll see, obviously, as things progress, how and when that proceeds as we go forward. The second area I wanted to flag was beyond the substance, was really the question of process. And the court spent some time, both in the IAA decision as well as in the Plants decision, about talking about the essential need in Confederation for both orders of government to work together in what they call cooperative federalism. And it really requires there to be honest conversations. By honest, I mean detailed, extensive conversations and engagement in order to tackle some of these complex problems that tend to span both areas, both orders of governments, areas of concern. And my experience as deputy was that this idea of cooperative federalism was something that wasn't something that I ever found in practice. The standard practice that I noted from our federal crown lately had been to announce an outcome. Often it was a detailed outcome, some engagement with preferred groups that the federal crown wanted to hear from, the production of draft documents of one nature or kind, whether they're draft regulations, and then sending those out for consultation with affected stakeholders and they included within that the provincial crowns. And it struck me that that process was always going to be destined for major problems, in that it didn't provide for some real discussion about the areas of jurisdiction, how things in fact were going to play out, and what were going to be the effects within provincial jurisdiction, which often turn out to be incredibly significant. So with that change, with the decisions that we've both seen and this constant request from the courts that we see more of cooperative federalism, I think all orders of government would be well served to spend some time thinking about how they were going to engage. The provincial crown and the federal crown, as we all know from our basic civics understanding, are equals. They're not one subordinate to the other. They both have areas of authority and they're equals in that regard. They are not just a stakeholder that can just be addressed in a simple flyby consultation. So the need for meaningful engagement is something that needs to change. And we need to actually see more of it between both orders of government. So that, I think, will be a significant change that will need to occur if we're going to move forward and address, admittedly, difficult, challenging topics, but in a way that is actually going to proceed. I'll just maybe wrap up my comments by saying, unless we see some change in approach, both in substance and in process, and how they're executing it, I'm going to anticipate the following things. One, more uncertainty in our regulatory processes. And that uncertainty is going to be viewed and expressed, I think, by people who would like to build projects, but who are now wondering, what does this process look like? Importantly, how long is it going to take? And do I have any way of asking excellent counsel like Brad Gilmour to give me some predictions about what the answers might be at the end of that rainbow? The second thing I think follows, and that is we will see less investment in major projects until we are able to provide clarity about our processes and some assurance that we are not going to have constant, significant, protracted debates about whether or not our orders of government are acting within, quote, their own lane. And then the third is, unless we deal with this, and I think we really must deal with this at a very senior political level, we're just going to exist as a country with greater tensions than are necessary within Confederation about who's doing what. The answer in my mind is to come back to this idea of cooperative federalism, to come back to this idea that we need some senior strategic conversations between our orders of government, and perhaps, and to be clear, that's not always going to be easy, but we really need to get together and figure out who's doing what and how we can work together in order to move things forward. I think both Brad and I remember days when substantial oil sands projects were moving ahead. They were done in cooperation between Alberta and the federal government. There was distinct but clear regulatory authority that in those days was exercised by the National Energy Board, and the Alberta Energy Regulator then wasn't. Yet that process went forward in a relatively effective fashion, and we were able, on behalf of Canadians and Albertans, to ensure that appropriate steps were taken to safeguard the environment and also move forward with economic matters. I'll stop there, and thank you very much for attending today, and I really look forward to questions.
Thanks a lot, both of you. Wow, that was pretty impressive. You simplified a really complex topic and gave us non-lawyers a great background in normal language, which is, it's not easy to do. So obviously, this is a very important topic. We're now at the Q&A part of this, and I'll just remind people to please put your questions in the Q&A box. My job here will be to get you out of here on time, but to stick handle these questions as they come in. We have one that's coming in the chat. Again, prefer the Q&A, but this is fine. From Adam, first, Minister Guilbeault stated that the that Environment and Climate Change Canada will be looking at amending applicable legislation to comply closer to the Supreme Court decision. What and or where do you anticipate the feds will attempt to provide them a more defensible case to regulate emissions, in particular provincially? And either one of you can jump in first.
Grant, I'm happy to maybe get started on that. I don't know what the amendments are going to look like. I think it very much depends upon how you read the decision. But I can tell you what I think is needed and what I think we need to do if we're realistically going to look at developing regulations that allow for the development of our natural resources, whether it's in the oil and gas industry or in the critical mines industry or any other major infrastructure projects. What I think the Supreme Court has said very clearly is that the jurisdiction that regulates the activity has broad jurisdiction and the other one has a more limited role. So if we start with that premise, what that means to me is that if it is a provincially regulated local work and undertaking, and recognize, when somebody comes to me and says, hey, I want to build an in situ oil sands project, I mean, what statutes am I picking up? They're all provincial, right? They're all, and that's because we have expert regulators in the provinces that regulate the entire life cycle of these projects. They regulate it on a day-to-day basis. They are the expert regulators in relation to these provincial local works and undertakings. So where does the federal government come in that? I mean, their expertise is in their discrete areas. Certainly if it's an interprovincial project or an international, that's their area. And the province doesn't participate in a material way in those proceedings. It certainly doesn't draft legislation to provide an equivalent public interest decision-making aspect. I mean, could we imagine that all the provinces draft legislation that says, well, if it's an interprovincial railway, well, you can't go ahead until we decide whether or not it's in the public interest based upon provincial priorities. And each province could design that. So I think the answer is, again, we need to do what the Supreme Court of Canada said, and that is go back to your area of jurisdiction. If you're the predominant regulator, then you regulate it. And in an example of, let's say, a provincially regulated local work and undertaking, the federal government may have a role, and they may have a very important role, but it would be in relation to things like fish and fish habitat. And I think the answer is, well, that doesn't mean that you jump into the whole process and you try to regulate the whole project. I think what it means is you filter your concerns or issues into the provincial process. That's taken into consideration by the provincial regulator when they decide whether or not the project is in the public interest. And then all of the information, well, not all of that information, this gets to another point, but some of that information from that process can be fed into the federal decision making. So I think that's the answer, is that if we're going to really realistically think about even things like an energy transition and being able to rely upon our own supply of critical minerals as opposed to relying upon other jurisdiction for those minerals, then we need regulatory reform in that regard, where the province is the primary regulator and the federal government can get involved, but only in those areas where it has a clear area of jurisdiction. That'll avoid overlap, that'll avoid duplication, it'll reduce the regulatory uncertainty as to what needs to be done and why, it'll focus expertise at the right level of government, it'll reduce litigation, and it'll reduce timelines. I think that's what in part needs to be done in any event.
And I'd just jump in. I think Brad's got it entirely right. We need to be thinking about how we build a system that works together, not thinking about how we build a system that can trump another system. And I'd say respectfully that, as I reviewed C69 back in 2019, it looked very much like it was a system designed to be the one ring to rule them all. And that doesn't end well. And it can't end well for our country, and it can't end well for proponents and the people that we're serving. So in my mind, it comes back to look for systems that are going to function well together, that are going to be able to work together in a sensible way. And again, it goes back to within your area of jurisdiction, as Brad just said exceptionally well, within areas that you're competent in. And I don't just mean legislatively competent in, but areas that you've got the expertise in. So if it's fisheries, which is a good one for us and one that applies across the country. Wonderful to hear what your views are on the fisheries piece. I mean, they should be doing that. Not entirely clear why they should be talking about emissions generally on any topic. Again, not an area of expertise, nor an area that it falls within federal jurisdiction. And indeed, I think one of the pieces that I keep hearing in the news, and look for Brad to comment on this, hearing in the news is that the federal government has some competence to deal with emissions, greenhouse gas emissions. And my question is, where does that come from? I think that the decision in the greenhouse gas pricing case is very, 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 very narrow. And we need to come back and remember that's all about setting the stringency on national carbon pricing. That is about as narrow an area of authority as one could possibly imagine. It is not a plenary authority to regulate on the topic of GHGs. And again, if I think if we could have some real detailed conversations, people understanding the boundaries and people willing to work together, we can end up with some compromise, some adjustment, perhaps in a very Canadian way, that can get us to an effective and efficient regulatory system.
That's
Maybe I'll just follow up on that a little
sorry.
bit, Charles, in terms of that issue of greenhouse gases. And I think, as I said at the outset, it's important, I think, that Justice Wagner, who's the Chief Justice, wrote this decision. He also wrote the majority position in the greenhouse gas pricing case, where as Grant said, that was really a very narrow expansion of power at the federal level under this peace, order, and good government aspect of the Constitution, which is narrowly relied upon by the courts. It's rarely used because the court recognizes that if they support legislation under that power, they really are changing the Constitution. So it's rarely used, but they did use it in that case. But in the impact assessment reference, Justice Wagner came back to emphasize the narrowness of that decision, and very clearly within the context of projects within a province, said that greenhouse gas emissions from a project within a province is not a federal effect. So, there were very clear statements. Justice Wagner could have used other examples other than greenhouse gases to make some of those points, but he repeatedly referred to greenhouse gases within the context of that reference decision. I think it's very important.
Thanks for that, Brad. Actually, this question that came in the Q&A references, it's related to your comment about competence, Grant. Now, more provincially, this is from our Bandakis. Do the provinces have the civil service capacity to put in place smart regulations that don't create a lot of burdens on companies with, say, 10 different IA equivalents? Is there an efficiency case for a federal or sort of a national as opposed to a federal regulatory process? Thoughts there?
Yeah, so I mean, one of the things that troubles me always is that you will hear this idea, wouldn't it be so much better if we just had a unitary state and the federal government regulated everything? Because that would lend itself to, I don't know, some form of uniformity or consistency. And I think Emerson had something to say about consistency being a bit of a hobgoblin. And my view is absolutely the provinces have the capacity to deal with any of these topics that are within their competency. That's foundationally why they're there. What's the real trick? The real trick is they're closer to the project. They're closer to what is going on in the various regions. They're closer to what the population within those regions, what their intense desires and concerns are, and they're able to actually deal with them. While I'm aware that, the federal government and my colleagues in the federal civil service, whom I respect, of whom there are absolutely many, they're there, yet I don't think that the mere employment by the federal crown lends to them some greater competency to engage in any of these topics. You know, let's be clear, there are topics such as nuclear energy where the federal regulator, the Canadian Nuclear Safety Commission, is incredibly competent, and I don't think anyone would ever purport to suggest otherwise. It doesn't matter to the provinces because it's a federal area. I would say, though, when I look at detailed things within a provincial jurisdiction, I don't know who knows more about the fish and wildlife in Alberta than the Alberta Fish and Wildlife folks. I don't know who would know more in Saskatchewan to look there about the potash industry than my colleagues in Saskatchewan, and so forth across the country as we go. So I think the idea, and we often hear that of perhaps there would be, again, one national approach, omits the fact that this is an incredibly large country that has got all kinds of regional differences that I think are helpful for us, to be honest. And we need to respect that different areas of the country will have different concerns, preoccupations, and the provinces can absolutely respond to those.
Great, thanks. Thanks a lot, Grant. Brad, any thoughts there?
Yeah, I guess I was sort of smiling a little bit there. I don't think I'd be a good regulatory lawyer if I didn't have the odd complaint with the provincial processes as well. But they tend to be more on the margins. But I think when you get into this issue of competence, that's important. And it's really, I don't know if it's competence, more like expertise. Do I deal with these activities on a day-to-day basis, or do I occasionally come in and look at an oil sands project in northern Alberta broadly? And I think it's the provinces that are regulating these local activities and fulfilling that function at the highest expert level. And there's some very competent and capable and expert people with the Impact Assessment Agency for sure. But the mandate is quite broad. And that's where, again, I look at that and I kind of go, well, okay, their mandate now is to look at that, or was at least, to look at that very broad physical activities regulation, which ranges from intraprovincial highways all the way through to power plants and pretty much every aspect of a major infrastructure project. And they are tasked with a broad-based review of environmental and other impacts associated with those activities. So that's a pretty broad mandate to be expert in all of those areas with respect to such a broad range of provincial, or sorry, of activities. Whereas something like the provincial regulators tend to be much more focused on those activities, and it's hard to imagine that there's something there at the Impact Assessment Agency level that wouldn't be there at the provincial level, other than perhaps a more focused assessment of things that are truly federal, like fisheries and similar types of things.
That makes sense. Yeah. Next question that's come in is related to the jurisdictional issues. Knowing this from Nancy Carlson, knowing that the federal government has jurisdiction over international relations, how can Canada better navigate the challenge of federal government making international commitments in the areas that affect provincial jurisdiction? I'm thinking of obviously greenhouse gases, but there's probably others as well.
I'm happy to jump in on this one. And again, there's no question that the federal government has the authority to enter into international relations and international agreements, and that makes sense. Yet, it doesn't mean that having entered into the agreement that the federal government has the competence to execute or to implement them. From an international law perspective, the existence of a treaty or an agreement is a matter as between states, but it doesn't translate instantly into our system to impose those laws domestically. So again, so how do we make this more effective? How do we make this more efficient? I think the answer the court tells us time and time and time again is cooperative federalism. So if there is a conference that is going to set some target or some outcome, and it is a matter that predominantly is going to be influenced or affects provincial competence, I would have thought it would have been useful and insightful to engage with the provinces, find out what's the art of the possible within that, and then proceed forward with a process that our federal government and Canadians could come back saying, we know this will then work because we've figured out the implementation. And, I want to be clear, the federal government has got its own authorities, and I'm not suggesting that they have to come on bended knee all the time to the provinces. That would be going far too far. But equally, it doesn't turn it into a diktat from the federal government that, oh, we have a thought, therefore you must do it. Neither of those things can be true. And without some engagement of saying, how is this country, for example, on critical minerals, the development of critical minerals, how are we as a country moving forward? How are we going to be able to look to develop minerals that are found in the Ring of Fire, for example? How are we going to do?
Froze up a little there, Grant. In the meantime, Brad, do you want to dive in there? Any questions?
Well, Grant's back. Do you want to finish, Grant? We lost you there for a minute.
Oh, that was all the good parts. Bottom line, cooperative federalism is the answer.
I think maybe I'll touch on it just briefly, Charles. There was one interesting aspect of the reference decision that I don't think any one of us on our team anticipated. And Justice Wagner briefly commented on the Migratory Birds Convention Act. And what was interesting in that, and it's related to this question, is they sort of mused that, well, where does the jurisdiction for that legislation come from? Purportedly, it comes from the treaty-making power of the federal government, but that treaty was signed at the turn of the last century. So in the 1800s, I believe it was, for example, signed by Britain, by the UK on behalf of Canada, and by the Sultan of India, for example. And it all had to do with the trading of plumage from birds for decorative purposes. That was its original thing. And now it's moved into the Migratory Birds Convention Act over time, where it regulates migratory birds, habitat issues. And the court seemed to be suggesting is that, well, is that validly tied to the treaty-making power? So I thought that was a really interesting aspect of the decision that we weren't anticipating, but it certainly raised that question. And then on greenhouse gases, I mean, this is something I'm still thinking through on my own, but I look at this issue and there's this sort of concept is, why is it the federal level of government that would be seen potentially as the jurisdiction that is best suited to regulate greenhouse gases? It's a global issue. No single nation can manage the issue on its own. But that doesn't mean that the proper jurisdiction to manage it would be at the provincial level. So in other words, when we look at a single country, why the national level? Why is that any necessarily more capable of managing it at the provincial level? And of course, we know the provinces are regulating greenhouse gases, and Alberta is an example of that, as well as the other provinces. They are regulating in those areas. So I think that's kind of distinct from regulating things like marine pollution, or say pollution that directly affects one province versus another, where, for example, there might be release of substances into a waterway within one province that inhibit the ability of another province to use that water resource. That, to me, more comfortably fits into something that might be more federal than this concept of trying to regulate a ubiquitous molecule like carbon dioxide that has, both positive and negative effects in the environment, and is really a global issue rather than one that is, specifically between provinces.
Thanks a lot. I have one another question coming in. I think it's going to be our last one. With apologies to Rick Anderson, he had his hand up for a bit here. So, Rick, if you're able to just speak your question, then that would be great. If you go on unmute. Maybe I have to do that. If not, maybe. See, I think you had a question on. You mentioned that your comment that the provinces have control over the development of natural resources and royalties. But if you had any specific questions, then that'd be great. Oh, I think we have you. I think we don't allow this. Sorry, this is I'm getting this from our folks here. So if you could just quickly put it in the chat. If not, quick question from or comment on uranium mining from Kent Smith Windsor. Any comments on that? In particular, Grant, he agreed with your concerns about the Species at Risk Act on failure and discriminatory application of the act at the provincial level.
Yeah, thanks, Kent, and hello. With respect to uranium, I think, and Brad can correct me, but uranium is one of those topics that has been declared by the federal government as a necessary work for the betterment of Canada. So it falls entirely within federal regulatory jurisdiction, as I understand. What I think is curious, again, and it's the inverse of what I've been principally talking about, that are matters that are provincially in principally provincial in jurisdiction with add-ons of the federal government. This would be the reverse. So the feds would be the principal regulator, and there may be provincial elements such as provincial lands dispositions or something to that effect that would need to be included as they would move forward. But again, it seems to me that if we could figure out a way that our regulatory processes could work in harmony as opposed to dysfunction, we'd be in a better spot.
Yeah, well said. I don't think I have much more to add to that, Charles. But again, you know, that's also that issue of competency. I mean, this is clearly an area where we have a regulatory authority at the federal level that has, you know, the requisite experience and competency to regulate those aspects of the uranium industry.
Sounds great. Well, it looks like we're just about at the bottom of the hour. I did promise that we'll get you out on time here. So I just wanted to thank you both very much. This is a terrific description, and I not the background, but also potentially going forward with, let's hope, better cooperative federalism and a more sincere effort to understand the issues of the provincial governments. I will mention that we have a few couple of upcoming events here, City Council Institute, on next Monday. We have the Mintz lecture on Canada's productivity crisis, how tax reform can help, with our CEO Bill Robson and Jack Mintz, noted tax expert. And then we've got pre-budget recommendations with Bill and Don Drummond in February. And we've also got coming up in March, EU's Opportunities for Canada, Reflections on a Steadily Deepening Partnership, webcast with Her Excellency Dr. Ailish Campbell on March 7th. I believe there's also an in-person roundtable next week with 3 chief economists if anyone happens to be in the Toronto area. So that looks like a great event. Again, thank you very much. Terrific. Thanks, Grant. Thanks, Brad. Much appreciated. And we'll see you next time.